morning. So we're close. He just asked me. Okay.
All right. Let's figure out how we're going to work through all these motions this morning. I don't. All right, so we'll do Ms. Grant first, and then the one that I'm most anxious about is Mr. Connors, since he's going to trial on Wednesday. But we've got Ms. Grant for the 9 o'clock. I see that she is on the call. You all right, Ms. Feely, with Ms. Grant appearing virtually?
Yes, and I have an update for the court. So I filed a motion relatively late last week based on, and this is.
This is your Jackson B. Deno,
Yeah.
where I learned a new phrase, ore tennis. All right, I had to look it up, but I know what it means now.
So this was my mistake from coming onto the case late. I was looking at a different statement than what Mr. Thomas is looking to introduce.
Okay.
And so when I watched, I thought that was the only statement. It was just on a flash drive. It said client statement. So I listened to it. It was very problematic, as I think Mr. Thomas could agree. But the statement he actually wants to introduce, I've since watched yesterday.
Okay.
And I actually don't see any.
Why don't we get all that on the record, and this will be a shorter hearing, and we'll be able to get more done this morning. All right. Good morning, Ms. Rivers. Can you hear me?
Yes, Judge. Good morning.
Good morning. All right, let's get on the record in 20 SC 175857, that's State versus Sherry Grant. Ms. Grant, do you mind turning your video on so we can see you, please? Ms. Grant, you able to hear me? Are you able to text her? Great. And we have someone on that's just listed as Zoom user. Do we know who that is?
I wasn't expecting anyone on my cases via Zoom this morning.
Okay, I'm gonna.
Your Honor, it may be a victim for the Shari Grant case. I'm not 100% sure, but my advocate is on, and I'm pretty sure she told me that a victim, victim's family may be on.
Okay.
There's Ms. Grant.
Did Ms. Grant appear? There she is. All right. All right. Ms. Grant, are you able to hear me? Can you raise your hand if you can hear me? I can see her, but it doesn't seem like she's getting audio. Can you hear us, Ms. Grant?
Yes, I can hear you guys now.
Fantastic. Okay, thank you. So Ms. Grant, we're going to talk a little bit about your case. You are appearing remotely. Your lawyer is here in court. I just need you to tell me on the record that you are okay moving forward with this hearing, even though you're not sitting right next to your lawyer here in court. You all right with that?
Yes.
Okay. Ms. Feely, my understanding is that Ms. Grant gave two statements to law enforcement in connection with this homicide investigation. And there was one that gave you grave concern, and your write-up of it gave me concern too, as to whether it would be admissible. But you learned from speaking with Mr. Thomas that that was not a statement he intended to introduce should this case go to trial, that there's a second statement. I'm going to let you and Mr. Thomas get the circumstances of that second statement on. And I just want to get both sides to acknowledge what I'm calling statement number one, which was from December 21, 2016. The state does not intend to use. That's the one that you, Ms. Feely, referred to as problematic. And that there's some statement number two, and we can identify it by a date, and that's one that is not problematic, and that no one at this juncture is objecting to either side being able to use at Ms. Grant's trial. Is that a fair summary of where we are?
That's correct, Your Honor. And I think, Mr.
Can you make sure you're near the microphone, please?
Yes.
Thanks.
And I think Mr. Thomas and I will be able to narrow it because I think there are things that need to be redacted, but I don't, for purposes of a Jackson Dino hearing, I think that the defense agrees that it's, there's not problematic. Miranda is read. We don't see an issue with the voluntariness of that.
When is the second statement given?
So Your Honor, the second statement was given approximately March of 2018.
Okay, so a couple years, well, year and a half later, Ms. Grant gave us a second statement. Ms. Feely has both of these. Mr. Thomas, you don't intend to rely on the December 21, 2016 statement.
That's correct, Your Honor.
Okay, so then the Jackson Deno motion as drafted is moot, but Ore Tennis, the defense is also acknowledging that there's a second statement for which defense says there are not voluntariness issues. You've reviewed it, Ms. Feely, and you feel that the Miranda waiver was knowingly and voluntarily executed by your client, but there may be some things in the course of the interview that need to be redacted. That's the kind of thing we could navigate on the eve of trial. I guess it will be your obligation, though, Ms. Feely, to flag those things far enough in advance that Mr. Thomas and his team have an opportunity to edit. It never works well when the defense attorney walks in the day of jury selection to say, I need these 19 segments removed. And you're right, because it's not practical that the DA's office in a day can go and snip it like that. And then we run the risk of, oh, did you press pause at just the right time? So if there are areas about which you have concerns, try to flag those further in advance.
Yes, Your Honor.
Okay. Was there anything else concerning statements Ms. Grant made that you wanted to cover during our hearing today?
Not in terms of statement. There is one other separate matter.
Okay.
Ms. Grant on the call.
There's also something I want to cover with Ms. Grant's case. Anything about the statements you want to cover, Mr. Thomas?
Nothing from the state, Your Honor.
Okay, so the March 2018 statement is coming in, perhaps with some redactions. And again, we can navigate that closer to trial. If there's disagreement, it may be everyone agrees that certain things can't come in. The December 2016 statement is not going to come in, at least not through the state. They recognize that there were some issues in the way it was obtained, and they won't be affirmatively using it. My question, unrelated to the statements, is where we are with the cell phones.
Yes, Your Honor. So we do have a cell phone. It has been dumped. Issue we're running into is our person. We have one person who dumps cell phones, and he has been on vacation.
The phone belongs to the person that some people think may be the actual shooter in this case?
That is correct, Your Honor. Yeah, so we have it. We have been able to get into it. We have dumped it. We're just waiting for our guy to get back so he can hand that over to us. Okay. Which I'm anticipating is going to happen today.
Okay.
Once it's handed over to us, I'll hand it over to Ms. Feely. And then we just need to take that information and get the cell phone number and request the cell site data. And that's something that'll happen today once we get that.
And the person to whom you believe, Mr. Thomas, the phone belongs, is that person alive and in circulation? Or so far the indictment is only Ms. Grant, but
Yes, Your Honor.
I think both sides, state and defense, have said, it looks like Ms. Grant wasn't the shooter. She may have, state's theory may be party to the crime, set the victim up, all sorts of things that may well make her criminally liable for murder, felony murder, et cetera. But I don't think the state's theory of the case was ever that Ms. Grant pulled the trigger.
Yes, Your Honor.
Is that a fact? I don't mean to commit you to that. That's just, it's gone through like 6 prosecutors.
Yes, Your Honor. My understanding now is going to be party to a crime.
Okay.
The person who that we theorize actually pulled the trigger. He's out and about. He's possibly in custody, but we haven't been able to confirm that.
Okay. But there's no reason for you to believe he's deceased. In other words, he's someone the state might be able to get its hands on, and then we would have a superseding indictment with Ms. Grant and Mr. Person.
Yes, Your Honor.
Okay. And does the state know his name? People have mentioned the name before. It's
His name is I think it's Jay.
I don't need it right now. People have referred to the phone as being his, like people attached a name to the phone that you have now extracted. So the extractor is back in the office and ought to be able to get that information to you and thus to Ms. Feely in the very near future.
Yes, Your Honor.
Okay. All right. That's what I wanted to cover. Ms. Feely, were there other things you wanted to cover in connection with Ms. Grant's case?
Yes, and I brought this up to Mr. Thomas. Ms. Grant is paying $300 a month for her ankle monitor, and that is becoming very hardship on her situation. I haven't been in Fulton County long enough to know how all that works. But if the court, if I were to draft an order with Mr. Thomas's consent, would the court consider reducing that amount? Or I don't think that was Ms. Grant.
No, that may be Zoom user. What I can do, we just need to get the language right, is switch it to a county funded ankle monitor. The dollar amount is a dollar amount, and we don't haggle with A&A monitoring or whatever the company is, but we also have the ability to just switch it. It's going to be the same monitoring company. We just switch it so that it's county funded rather than defendant funded. And I don't have an issue with that. I'll hear from Mr. Thomas if he has a concern about that. It would mean that Ms. Grant is still subject to whatever curfew limitations, et cetera. The only thing that would change in her bond is that the county would be paying for the ankle monitor. There would be no relaxation of any of the provisions. So I'll let you guys confer on that. Do you have a perspective? Ricky M369 doesn't like the fact that the county might pay for it. I assume that's someone associated with the deceased. And he just blew a chat to everyone, voicing opposition to the county paying for that. So I note that,
Yes, Your Honor.
but that's not what this is about.
So yes, Your Honor. The state doesn't have an objection, Your Honor.
Okay. Ms. Grant needs to be tried. I think this is a re-indictment. Clearly, it's old because the homicide occurred in November of 2016. That is more than 5.5 years ago. How long do you envision it taking, Mr. And it didn't age on your watch. It has aged on lots of people's watch, but how long do you envision it taking to get the cell site information? And why would I need to wait for that? If it's not Ms. Grant's phone, then whatever is on the phone you've recently extracted, that might help you conclude you want to indict phone user. But presumably you've got what you need on Ms. Grant because she's been indicted for a while now.
Yes, Your Honor. And I anticipate like any information we get from the phone may actually be Brady material that we would need to hand over. Honestly, I cannot tell you how long cell site requests take. I can get that information and let the court know via email later on today.
Okay.
But I can't intelligently tell you how long that'll take.
Help me understand how the location of someone else's phone is helpful to Ms. Grant. I don't know the flow of the case.
So basically, Ms. Grant's story is that it was her boyfriend who pulled the trigger, not her.
And is this the person whose phone it is?
Exactly. Right.
Okay.
So it's his phone. So if it confirms that he was also in the area with Ms. Grant, it would bolster her case that it was most likely her boyfriend that pulled the trigger and not her.
Okay, but if your theory of the case is that the boyfriend pulled the trigger, that doesn't, I mean, it corroborates the story you'd be sharing with the jury, and you still have Ms. Grant as party to a crime, making her liable for the death as well. So my question wasn't, why are you turning it over? You should, and you're going to, but why do we need to tap the brakes on, I guess, because the defense would want to, insofar as they're trying to build up Ms. Grant's credibility through her statement, or should she testify, that is the Brady aspect to it.
Yes, sir.
Okay. All right. So if you could get an email to me and Ms. Nelson and Ms. Feely as to when Ms. Feely can get the phone extraction. It's not your job to get cell site information for Ms. Feely. She can get that too. She may choose to, she may not. You may want it, but that once the defense has the extraction of the phone, I think it's time to start discussing when we can get Ms. Grant's case on a trial calendar, because they'll have what you have and you'll both have the same amount of time to work through whatever might be on that phone.
Yes, sir.
Okay. And you think this week that information will get passed?
Yes, sir.
Okay. All right. Ms. Feely, did you have anything else you wanted to bring up in Ms. Grant's case? All right. So if we look to get Ms. Grant's case at long last on a trial calendar later this summer, it seems like both sides should be ready, unless the cell phone extraction leads to, hey, we need to hire an expert, et cetera, but you could bring that to my attention. Okay. All right. Ms. Grant, do you have any questions about what we've just discussed in terms of scheduling?
No.
Okay. Ms. Santos, is there anyone on the call? I don't know that there's really, this isn't the forum in which I'd be hearing from any of the victims' family members. They are welcome to tell me that this case has taken too long to get to trial. I agree with them. But we aren't making any substantive decisions right now. It sounds like the lawyers on both sides agree which statement should come in and which one shouldn't. Ms. Santos, are you in the mix?
So Your Honor, I'll talk with the victims after this, and if there's any concerns, I'll bring it to the court.
Well, Ricky M 369 wants to say something. So Ricky M, if you want to unmute, if there's something you want to share, I'm happy to hear it.
Yes, we do want to say something. We want to know why.
Can you tell me who you are first, just so the record reflects?
I am Barbara McKee. I am Telvin's aunt that raised him up from a baby. And we want this to go to trial because we cannot have any closure until this go to trial. Whoever pulled the trigger, we want that person to be accountable as well. Not just only Ms. Grant. We want that person to be accountable.
Okay, I understand that. And I think you've heard me say now a couple of times, I can't quite figure out how a case from 2016 is still hanging out here, but I'm pretty focused on getting it to trial, whether it's Ms. Grant as the defendant or her boyfriend, ex-boyfriend. I can't indict people. The case I have is State versus Ms. Grant. And that's the one I want to move forward on. And it's clear you do too, and you're very justified in feeling frustrated that it's been so long, and your request for closure is very, very understandable, and you have a right to that closure. in the form of a jury saying guilty or not guilty. You know, it's the jury that decides, members of our community. I'm trying to tee that up later this summer. So you will be contacted by Ms. Santos as we figure out when exactly we can do that, okay?
I appreciate that, yes.
You're very welcome. Thank you for dialing in.
Thank you, Your Honor.
You're welcome. Mr. Thomas, anything else in Ms. Grant's case?
Nothing else from the state, Your Honor. Thank you.
Ms. Feely?
No, you're.
All right, thank you. Ms. Grant, you are free to go. Ms. Feely will get me a proposed order about this ankle monitor modification.
All right, thank you, Your Honor. May I be excused?
Yeah, thanks for coming down. So is it all right if we start? Mr. Connor's here and that, oh, Ms. Patel was here. She'll be right back. Yeah, it'd be great if we could turn to the 413. I think that was what was next up.
Well, Your Honor, I think we may be very close to a plea, which would be a more efficient resolution of this case.
It sure will. So what do you need to do?
I've spoken with him already this morning, and I think if I can just make sure that he is completely fine with his decision, I think we would be able to move forward later this morning after just a few minutes.
Okay. I'm not rushing anything, especially not that. So why don't you chat with him? This kind of case, I would want him signed up, meaning the written form as well, not a shoplifting. I can sit tight. I'll probably go back and get some work done and then come back out. Let me see what else we have this morning. So that would take care of the 413. And then we had 2 cases that involve Mr. Cladis, assuming we can get him from Judge Richardson. And then there was a Heavenly Mitchell. Do you have Heavenly Mitchell? Ms. Besa does. That we ought to talk about. But Connor first. So you focus on that, Ms. Feely. And then we'll see if that happens. Rooks is ahead of Mitchell anyway. And so we'd need to let the lawyers in that case, Ms. Hilton and Korn, know that they've moved up to the batter's box.
I've spoken to Ms. Hilton. She's aware also.
Good. I appreciate you guys communicating. I mean, everyone needed to be on sort of warm standby, but there's a difference between the cases resolved and maybe we're going up. So you talk with Mr. Connor and let's see what we can do. Thanks.
So that I have.
So the injunction. Yeah, it's just the sexual battery. And then there's the child molestation. Basically counts 11 through 15 is what we'd be proceeding on. And it would be life to sort of 10. So with the balance.
And I'm fine with that, but I'm wondering how we got life with just those counts.
Oh, for child
Yeah,
molestation.
I mean, you can do Roman linears if you want to. I just want to make sure.
Yeah, no. I feel like it's probably better. For child molestation, you can do life on probation. So I'm just gonna do, that's the only way I was able to get. So I'm gonna do life on probation for both of those. And then I'll just do the 10 years to serve on the sexual batteries. And the probation on it.
Okay.
It's just easier that way, I guess.
So,
Like, so 10, balance for 11.
You've got Tolbert and my God. Sometimes they see it, but you never sure.
Yeah, I got a better memory. I just remember down here thing.
Dr. Florette, you okay?
How you doing?
The family should feel good. Good morning. You guys are here for what case?
She's here for Carlos Dill, Your Honor. And then she's.
I don't recognize, I can look it up. Do you have a case number?
No, I don't, so.
Okay. DILL
Yes.
Carlos. Carlos Renard Dill. That is in fact my case. But our next court date is August 5th.
This the last time he was here was May, no, not May. It was in April sometime.
He had his plea and arraignment on April 6th. You're exactly right. And the public defender's office is representing him. So Ms. Feely, who's working on a case she needs to focus on right now, will likely have the case for, how are you related to Mr. Dill? Okay, so your son should be represented by Ms. Feely. She was not with the office yet in April. She came from another jurisdiction. So Ms. Primovic, who is a supervisor, was working with your son initially. But Ms. Feely will likely have the case. So April was that. I entered a scheduling order.
Yeah, there were no particularized motions filed on that case, so that's why.
Got it. Thank you, Ms. Nelson. So the defense attorneys looked at the record and concluded that there was nothing to suppress. So the next event will be on August 5th. In the afternoon, when I will talk with the lawyers for your son and the prosecutor, and your son will either be here in person or virtually, on a screen, to make sure everything's ready for trial. Because right now it looks like it should be. If the answer is yes, then the goal would be to get the case in for trial. So this is moving at a very, very different pace than the case you just heard about, which was from 2016. This case involves an incident that supposedly occurred just last November, right around Thanksgiving. So I don't know what someone said to you to make you think we had something today, but you should make sure you get Ms. Feely's contact information before you go.
Yes, he mentioned that he had called and stated that he was given some documents in regards to having the court date for today's day.
Okay. He, your son?
Yes.
Okay. Yeah. He must have gotten confused, or someone handed him something that was mistaken. But August 5th in the afternoon would be when Mr. Dill is next in here. But again, you should get Ms. Feely's contact information before you go, because that's the lawyer who will be representing him.
Okay, thank you.
You're very welcome. You all are here for Mr. Lloyd? Yeah. So this piece of paper you received was accurate. What it said was if there were motions that Mr. Lloyd's attorney had filed, they would be heard today. But there were not motions that were filed. So this was we blocked off this morning to hear like if there was a motion to suppress or something like that. But Mr. Lloyd's attorney, in examining the record, determined that there were not motions to file. So Mr. Lloyd's not here. There aren't motions to argue. Yes, ma'am.
Your Honor, but my son filed a motion himself. That wasn't.
Say that again.
Motion himself. He did himself. He filed for the motion himself.
So he did file. So he filed one motion for bond reconsideration, but a defendant who has a lawyer, if he files something on his own, it has no effect. It has to go through the lawyer. So if your son wanted to represent himself, which is not a good idea, then he could file things and I would need to work through them. But your son has a lawyer, and the only motions that we calendar and bring people to court for are motions that come through the lawyer. I will tell you this, your son's, he's swapped lawyers.
He didn't do it on purpose.
No. I didn't say it well. Your son didn't do anything wrong. I don't know why he's in jail. I'm not saying about that, but your son is represented by the conflict defender's office. So not Ms. Feely's with the public defender's office, but they had some conflict. Maybe the person that your son allegedly pointed a gun at used to have a case with the public defender's office. I don't know what the conflict was. Doesn't matter. They couldn't represent Mr. Lloyd. And so we have a group of good lawyers who fill in when there's a conflict from the public defender's office. They've switched. So the guy who had my cases doesn't anymore, but he's still listed as the lawyer. So what I need my staff to do is to reach out to the lawyer who ought to be working with your son to say what's going on so that he can meet with your son and figure out what's next. My answer to another question you may have is, well, what's the next court date, is the same that I gave that young lady. It's August 5th in the afternoon. That's when we're going to say, is this case ready for trial?
So what was that paper I handed you about? What?
So this is something that came in the mail to your son saying, we've received the motion you filed, but because you filed it, you've got a lawyer. The court's not necessarily going to rule on your motion. Your next court date is today, but that's only if the lawyer had filed motions. And
I'm sorry to interrupt. Is there any reason his public defender are not trying to get him a bond? So it was Sheldon, some guy named Sheldon.
Yeah, so Sheldon Johns Harris.
No longer with the court anymore.
Correct.
He's supposed to file a motion too.
Yeah, supposed to file months ago.
So that's why what I said is why I said what I said. We need to, my staff will reach out to Mr. Cladis.
Right.
That's the lawyer who now has your son's case. And we're trying to manage that transition. It's a little bumpy. But that's what needs to happen next is Mr. Cladis needs to get on out there and meet with your son to understand what your son's perspective is, look at the case file. It doesn't look like it's a real complicated case file, just looking at these charges.
Mr. Harris, Sheldon Harris, he was supposed to let him know what's going on before he left.
Yes. And it would be nice if it worked that way, but I am learning, it's not just your son's case, that it was not a real good handoff.
Not fair. He didn't let him know the situation with my son So he could, before, Mr. Harris left.
Yep.
I have another question, Your Honor.
Yes, ma'am.
If I hire an attorney, could my son be seen before that August date or not?
So if you hire an attorney, that attorney is going to take a look at the case file and talk with your son, maybe talk with you and say, hey, here's what we need to do. And if there's something that is urgent, then sure, we could get together before that August 5th date.
Melnick is gonna be, I think you know Melnick.
I do.
Jonathan Melnick.
Yep.
So you think there's possibility if I hired him, now so I can get a date, I just wanna know before that August.
So I'm not promising you anything. Mr. Melnick may look at the file and tell you, we want to wait. Okay, but he may tell you we should wait for that August date. I don't know what he's going to tell you.
I waited now, because I had met him, what is this, June, back in like March, and I said, well, Mr. Melnick, I'll wait, instead of paying you all this money, I'll wait this day. I'm thinking today, my son gonna get a bond here.
Yeah. So the reason why we're not having that conversation is because your son filed that motion and not the lawyer. I'm going to make sure Mr. Cladis turns his attention to your son. You may choose to bring Mr. Melnick on board. He'll need to file an entry. For now, the lawyer of record will be Mr. Cladis. Right now it says Sheldon Johns Harris, but he's out. Yep.
They've been there since Christmas.
Yep, I see this, because the incident, well, a little after Christmas.
Yeah, 2 days after Christmas.
Yep.
2 days.
Just before New Year's.
But
Okay.
Like you said, you're not sure if I hire Mr. Melnick, you get a date before that August, not promised.
Right, you should ask Mr. Melnick that question because he's the one who would decide whether to file something or not.
I thought, because you said your next court date is August, I thought.
Well, the next scheduled court date is in August. But like I said, if there's something that comes up that is urgent or is an emergency, then we might see people before then. But if Mr. Melnick simply says, hey, could we have that conversation that's supposed to happen on August 5th before then? Now, that's a date that was set long ago. But Mr. Melnick might say, I want to talk about bond. And maybe that would happen. But to manage your expectations, what we might do is say, what we'll do is talk about bond when we're getting together on August 5th. I don't know what the schedule looks like.
Long time, because my son has the issues and he hearing voices and, and stuff, he's bipolar, so it's
Okay.
kind of sad.
Yeah. Well, my goal is to try to get these things resolved as quickly as is safe for everyone. And I'm hearing you that he's been sitting around for a while. So I'll do my part, which is to get Mr. Cladis plugged in, and then you'll think about what to do with Mr. Melnick. Okay?
In the meantime, you will speak, with Mr. Cladis.
Yes, ma'am.
Thank you so much.
Yep.
I told him like it expires. So I told him.
You're welcome. Take care.
I think it's possible he needs time to think about it, but I was just back there saying, look, it's we need to do it now. And he was just kind of like, I can't do it. I would call it back for it. I'm trying to get you one. Like, yeah, I mean, I don't know what else I could do. Convince him that this is the least, like this is as good as it gets,
Yeah.
You need to do it.
I mean, unfortunately.
So I explained all that to him because this is a little. Have to do it this way.
Okay.
Should we bring him out?
I guess we have to do the 413. Okay. Okay. Good.
Ms. Feely, are we good to go?
Your Honor, I think Mr. Connor, at this point, would like to move forward with moving towards trial,
Okay.
not ready to enter a plea today.
Okay. We should do the 413. I'll probably start by talking a little bit about logistics between now and trial. And then we can do the 413. All right. Can we bring him out, please?
And Your Honor, before we do any of the motions, I'd like to put the offer on the record and.
All right, well, let me get the record started with.
Yeah, whenever we're ready.
Great, we are about ready. Ms. Rivers, you good to go?
Yes, Judge, I'm ready.
Okay, we are going to get on the record in 18 SC 162181, State versus John Connor. Mr. Connor is here in court. Good morning, sir.
Good morning.
He is here with his lawyer, Ms. Feely. We have Ms. Patel from the state. I had been advised that there was the possibility that Mr. Connor might be resolving his case short of trial, but it sounds like that is not what we're going to do this morning. And so what we do have on the agenda is a hearing about the state's notice to introduce other acts evidence through OCGA 24-4-413. It looks like there are 2 alleged incidents of child molestation that the state may try to admit during trial. Before we do that, I want to talk a little bit about logistics over the next few days. And I think a good segue into that is by having Ms. Patel do exactly what she asked to do, which is to get on the record what the state's offer is now, how long that will remain available, and what the consequences are for Mr. Connor should he go to trial and not fare so well. If there's a guilty verdict, what the other scenarios look like.
Thank you, Judge. Originally, I think about a month ago at the pretrial conference, the state had offered life to serve, 10 on the rape charge, the incest charge, and the aggravated child molestation, aggravated sexual battery, which are non-parolable offenses. On Thursday, June 23rd at noon, I then gave an updated offer to Ms. Feely after the initial offer had been rejected, saying that the state would null pros counts 1 through 10. So Mr. Connor would be pleading to 2 counts of child molestation and 3 counts of sexual battery, all of which are parolable offenses. This was in light of Mr. Connor's diagnosis, and during trial prep, we thought maybe this would be a fair resolution. So I had offered life to serve 10 with the balance probated on both child molestation counts, 5 to serve on each of the sexual battery counts, all to run concurrent. So Mr. Connor would be looking at life to serve 10, balance probated.
So you're using a phrase that I don't understand.
Yes.
The life to serve 10, is that the same thing as 10 years in custody followed by a lifetime of probation?
Yes, that's correct.
Got it. Which is not a sentence that Mr. Connor could get if he's found guilty of any of the, looks like there's 3 incest and 3 rape charges in the indictment. Those rapes would be a minimum of 25 years, non-parolable, non-probatable. And so it could be, as you're phrasing it, life to serve 25.
Yes.
So serve 25 years in custody, followed by the remainder of your natural life on probation.
Correct. And this offer that I sent on Thursday, I indicated to Ms. Feely, and she said she had indicated to Mr. Connor that it expires today at noon.
Okay. So if Mr. Connor were to act in the next 2 hours and 10 minutes, he would get a recommendation from the state that would result in 10-year terms of incarceration. You get credit for all the time you've already served, which I think is many years. And this may be the most important piece. Those are parolable offenses, unlike rape and incest. Is that correct, Ms. Patel?
That's correct.
So 10 is still a big number, but it's a number that could be shortened by pardons and parole.
Yes.
And 10 is already smaller by however many years that Mr. Connor's been in custody. After noon today, there's no offer on the table. A plea at the time of trial from me would need to be a plea to the indictment. I guess the state could dismiss charges still. I can't stop them from doing that. But if we're starting to bring in jurors and Mr. Connor decides he doesn't want jurors to hear about these allegations and is worried about their ability to navigate the evidence in this case, you're free to enter a plea at any time. But it sounds like it would be a very different landscape. It would be pleas to the incest and the rape charges. And the lowest sentence that I could impose would be a term of 25 years in custody, again, without parole. So while you have served a good number of years, there's at least 20 left in that scenario. And I share all that, Mr. Connor, not to say, gosh, one sounds good and the other sounds bad. None of this sounds good. It's you staying in prison longer, you're not well, et cetera. But I do want to make sure you appreciate the difference between where you are right now with the state's offer and where you will be later today. Because then I won't call it a point of no return, but we will have shifted to, then let's do this trial. You're entitled to do that trial, and a jury might acquit you. And then you're all done with this case. The jury finds you not guilty. I don't know if you have other charges keeping you in, but in Fulton County, you'd be done. That is the best possible outcome for you. I don't know the strength of the state's case. I don't know the weaknesses in there. You and Ms. Feely have been spending a lot of time working through that. But if you harbor serious reservations about what might happen at trial, I need to make sure you appreciate the difference in outcomes, because if a jury does find you guilty of even one of the rapes or incest, takes one, that's that mandatory minimum non-parolable 25 years. So Ms. Patel said a whole lot. I've said a whole lot. I want to make sure you understand where you are now through noon today versus where you'll be starting this afternoon. Do you feel like it's been adequately explained to you?
Yes.
Okay. And your choice right now is to move forward to trial.
Yes.
Okay. All right. Then what we need to do next is I need to hear from Ms. Patel about the two other act situations. The notice references an incident from 2002 in Henry County, and then an incident from 1991 in a Sullivan County. I don't think that's in Georgia. Doesn't need to be in Georgia. And I'm going to have Ms. Patel share with me a little bit of how she thinks the state could prove up those transactions. Mr. Connor, I'll let you know in case you and Ms. Feely have talked about this some. There is law, it's statutory law, that allows the state in a trial to bring in other allegedly bad things a defendant did, even though that's not what you're on trial for. Generally, the rule is if you're on trial for burglarizing a house, the jury doesn't get to hear about, 10 years earlier, you smoked marijuana, or 2 days later, you punched someone in the face, because the case is about, did you commit the burglary? And the state's burden is proven that you went into someone's house to take something. That's it. But there are circumstances in which the state is allowed to bring in these other situations that have nothing to do with what your trial is, but they might help show intent or a pattern or identity or something like that. The rules of admission are very liberal when it involves child sex offenses. Normally, the state has to justify why it wants to bring this information in. And there are very limited purposes. But when we're dealing with child molestation and things like this, actually, those restrictions are lifted. And the state is permitted to argue to the jury, hey, you know why you should find Mr. Connor guilty of this case? Because he's done it before. Normally, if someone said that, Ms. Feely's up like this, mistrial, we have to do the trial all over again. But when we're dealing with things like child molestation, the state actually can argue what we call propensity evidence. We know he burglarized the house this time because he burglarized a house before. That would not come in normally, because the fact that you committed a burglary before doesn't mean you did this one. But with child molestation, with rape, the legislature has passed laws that allow the prosecutor to argue that propensity information. And Ms. Patel would be within her rights if I admit either or both of these incidents, Henry County and Sullivan County, to tell the jury. Now, you've heard about what happened in Henry County. That shows you what kind of guy Mr. Connor is. That's how we know he did these things to Heather Connor, whatever it is you're alleged to have done in the main indictment. I want to make sure you understand what we're working through. Yes?
Yes.
Okay. So, Ms. Patel, you're welcome to provide the purposes, but that's not that, the three elements of the 404B, one of them is largely removed from the equation with 413 and 414. So I need to be comfortable that you could prove by a preponderance that Mr. Connor did these things. And then we need to talk about the 403 balancing.
Okay.
All right.
Absolutely. So I'll start with the older case. The one that I said was Sullivan County. I think there may have been a change with the counties over time, but in 1991, specifically February 26th of 1991, this case was investigated by the Cleveland Police Department.
Is that Cleveland, Tennessee?
Cleveland, Tennessee.
Okay.
I hate to interrupt. Is the state just going to proffer, or?
I allow them to proffer. I want to know how they would prove it up. If there is a witness or there are witnesses who you think need to be examined outside the presence of the jury, we can do that if we go to trial. And that's often how these play out. So I'm all right with a proffer at this juncture. Ms. Patel would need to identify how she plans to get this. I don't know, maybe Mr. Connor has a certified conviction from Henry County for child molestation in 2002. That's a different ball of wax than, well, whoever Joshua Williams is going to come in and talk about what he remembers occurring 20 years ago. So if your pushback on that is, well, don't you think we'd need Mr. Williams to say something on the record outside the presence of the jury? You may be right. At this juncture, I'm all right understanding how the state would try to prove it up.
I understand that's the court's preference. I would object to proceeding by proffer just for purposes of the record, though.
Okay, noted. So Cleveland, Tennessee.
Yes, Cleveland, Tennessee. This is 1991. The victim was a 13-year-old girl by the name of Angela Shoemake. She goes by Angela Fisk. Now, her name, her number, her address, everything is on the witness list that was served on the defense. Miss Fisk is able to come in and testify. I've spoken to her about the case. In 1991, she and her mother, Lottie Shoemake, were living with Mr. Connor's family. At that time, he was known as John Walls. His mother, Sherry Walls, and his father, Robert Walls, had basically taken in Miss Fisk. They lived down the street for a little bit. Then she said they had been living with them for some time. Either way, they were family friends for about 25 years. She was 13 years old and Mr. Connor was 19 years old at the time. Miss Fisk says that they had started almost a sexual relationship. At the time, being 13 years old, Ms. Fisk will come testify and say that she thought she was in a relationship with Mr. Walls. She thought that he was in love with her. However, as an adult woman looking back on it, she sees the problematic age gap that there was, and that there was some grooming behavior as well. This report had stemmed from Miss Sherry Walls, who is Mr. Connor's adoptive mother, and Miss Lottie Fisk coming downstairs to the basement and seeing both Angie Fisk and Mr. Connor in a compromising position. At that point, the mothers had gotten angry and were screaming at both John Walls and Angie Fisk. Ms. Fisk says that at that point, the blame had fallen on her. However, they had gone and made a police report to the Cleveland Police Department. The paperwork that I had served on the defense back, almost over a year ago, had some statements from both parents, had a statement from Mr. Walls regarding the fact that there was a sexual relationship.
When you say a statement from Mr. Walls, meaning Mr. Connor?
Mr. Connor, yes.
Okay, he gave a statement to the police.
Yes, he did. He gave a statement to the police. However, at the end of the investigation, the police had decided that Mr. Connor, I'm just going to refer to him as Mr. Connor, Mr. Connor's family and Miss Fisk's family could, quote, sort it out on their own. At that point, Miss Fisk was committed to a mental institution with, I guess, her mother had concerns that she had a sex addiction, according to her. However, Miss Fisk said that she was not there for very long. She was released. Unfortunately, Miss Fisk has had some drug abuse issues. However, she has been clean for 6 years, and she's willing and ready to come testify in this case. So there was no indictment drafted with this case. There was just a police report. However, the case was dropped, I think, it was just a product of its time, I will say. However, like I said, there's a full investigation, a full investigative report that was served on defense with all the details, and Ms. Fisk will be able to come in and testify.
Okay.
And then moving to the 2002-2003 case, this was involving Mr. Connor's stepson, Joshua Williams. Mr. Williams we are in contact with him, and he's able to come in and testify as well. We anticipate calling him. His information that's on the witness list is current and accurate. He can be reached on that number and at that address. The Henry County Police Department had been contacted by Josh Williams' uncle. He had disclosed to his uncle that John Connor had sexually molested him. He said that he gave a forensic interview. The victim had told his uncle that the defendant would have him perform oral sex on him, and would have Josh touch the defendant's penis with his hand. Josh said that Mr. Connor would also show him what to do by touching Josh first. He disclosed all of the same incidents and all of the same acts in his forensic interview as well. There were interviews with Mr. Connor's mother. Again, Henry County did an entire investigative report. However, the case was, again, I guess the detective had applied for warrants. However, they were denied by the judge, citing lack of probable cause and not enough evidence. I think this is, again, a product of its time as well. This is 2003. The detective is also someone that we can who will be able to come in and testify as well. However, I think we'll be able to sufficiently lay enough foundation and sufficiently have Mr. Williams come and testify in this case.
How old was Mr. Williams at the time?
At the time, he was, sorry, let me do the math really quickly. I believe he was 14.
Okay.
But I can confirm that.
How old was Heather Connor in the window we're looking at? I know it spans a few years.
Between 11 and 14 years old.
Okay. And Mr. Williams is or was Mr. Connor's stepson?
Correct.
Okay. What was the uncle part? He disclosed to the uncle?
Yes, he disclosed to his uncle. The uncle is the one who had taken him to the Henry County Police Department.
Okay. Got it. Okay.
And I think that nothing further when it comes to the proffer, Your Honor, but as you stated, the law on the record, we just ask that you grant our motion to admit these two incidents.
And the primary way you would seek to demonstrate by a preponderance of the evidence that these events happened would be through the actual victims, not
Yes.
old paperwork or my stepdaughter told me, but through the folks who were there when it happened.
Yes, correct.
Okay. All right. Ms. Feely, tell me your thoughts about admissibility under 413, given what you've heard.
Yes, Your Honor. So the state's burden is to establish that there will be sufficient proof at trial for a jury to find preponderance of the evidence standard that these acts were committed by Mr. Connor. I think there's some problems, particularly with the Joshua Williams proffer, in that as the state conceded, and as I have the paperwork as well, a magistrate court judge found there wasn't even probable cause. So for this court to find by a preponderance when all we have is a proffer.
Well, but you've read what I haven't read. What is your take on why the magistrate court found that? Did Mr. Williams not testify? Was it a detective? And if Mr. Williams comes in here and says, that's my stepdad and he made me do X, Y, and Z, I don't know how the state's not meeting its burden. I mean, you can impeach Mr. Williams, cross-examine him, et cetera. But if the victim comes in and testifies, that would seem to cross a pretty significant threshold. But I heard what you heard, which is that a magistrate said, I don't find probable cause. I just don't know. Back then, Mr. Williams may have been 14. He didn't testify, or he was afraid, or who knows? What is your sense as to how it went down that way?
On page 7 of the Henry County Police report that I know Your Honor doesn't have, but it says it was his opinion that additional evidence was needed to file charges against John Connor, and declined to.
The magistrates.
It doesn't say in my paperwork what that person's name was, but it does say the name of the district attorney who presented the case.
Okay.
So without more, I think we would ask the court to rule that there just simply is not, I don't know how the court could find by preponderance of the evidence when it wasn't found at the time, 20 years ago, that there was probable cause for an arrest warrant.
Well, I don't know that you will, but if you manage to get your hands on a transcript from a preliminary hearing or something that sheds more light on it, we can talk about it. But my thought would be that we have Mr. Williams talk a little bit on the record, but outside the presence of the jury, to address your concern. I understand your concern. I had a similar reaction when Ms. Patel was being very candid. Hey, there was not a finding of probable cause, but in the same way that someone could go to trial and be found not guilty, and that incident could still, I know it's a different burden of proof, but case law is pretty clear. A not guilty verdict about an incident doesn't prohibit that incident from coming in 404B or 413, 414. This is a lower level of proof that the state did not meet at one juncture, but that to me doesn't preclude admissibility. It makes me want to have Mr. Williams answer a few questions in front of us, but not the jury, before he can testify.
And the other thing that I would bring up on sticking with the Joshua Williams is just the extremely prejudicial nature of, I understand that Fulton County is a fairly progressive county, but the same-sex element of the victim and Mr. Connor, I think, is extremely prejudicial. And while this is a 413, it's still subject to the 4-3 balancing that the court must do. And we think it's our position is just complete, like, undue prejudice that would not allow Mr. Connor a fair trial.
Okay. I did look through the indictment, but it looks like Heather Connor is the only named victim in the indictment. So this does shift the dynamic a little bit, this particular incident. Okay. All right. And the Cleveland, Tennessee, Ms. Fisk situation.
Yes, Your Honor. So that was over 30 years ago. The age difference is, I think, very significant in that this is accused of grown man and a daughter, a minor daughter. versus this is a situation where the two were essentially peers. And this, again, was not prosecuted despite authorities being involved. But if it had been prosecuted, I think it would have been more akin to like a stat rape. The significance of that is that the intent element would be different versus what we have here in this indictment. So we would submit that, again, just generally similar transactions in these types of cases are extremely prejudicial, and I know the court has to balance that, but additionally, there is the difference in the intent element.
Okay. Ms. Patel, anything you want to add in response to, well, I'd like your thoughts as to both those arguments. The prejudicial nature of the Henry County case because it's the same sex encounter, and then with the Ms. Fisk situation, one is its extreme age, but two, it was a different dynamic, as you even described. You said it sounded like there was some grooming behavior, but Ms. Fisk also viewed it as a somewhat romantic situation.
Mm-hmm.
The age difference was much less significant than the charged conduct in this case.
And I'll first talk about the temporal remoteness. There is case law that allows, because 413 is a rule of inclusion, there is case law that allows extremely old incidents to come in, even if it is 30 years. I guess they call for a common sense assessment of all the circumstances. So seeing as Ms. Fisk is able to come in and testify to those acts at this point, although it is an old incident, it's still, we're still able to establish exactly what happened through her. As well, when it comes to the fact that it was I guess at the time, Ms. Fisk had thought it was a consensual relationship. Ms. Fisk was too young to consent. At age 13, she was having a full sexual relationship with a 19, almost 20-year-old male. I think a lot of the police report and statements were actually skewed by both parents who were just trying to keep the relationship between them calm and fine. There's also a lot of grooming behavior that Ms. Fisk can talk about when it comes to her relationship with Mr. Connor, just statements that he would make to her. So, I mean, although many children see the adults in their life and don't want to blame them and do still feel this sense of love and affection towards them. So to her, being in this family relationship, she saw Mr. Connor as kind of like not an older brother, but just an older authority figure. So it wasn't necessarily a romantic relationship. It was something that had spun off of grooming. And the act itself is incredibly similar to the acts here where Heather is Mr. Connor's daughter. So there is that similarity.
You've emphasized grooming a bunch in your description.
Mm-hmm.
Are there parallels that you see between what Ms. Fisk said Mr. Connor would do to get her comfortable about what was happening with what Heather Connor would say Mr. Connor did to get her comfortable about what was happening?
Yes. With Heather, the grooming behavior was a little bit, and she was given alcohol, and she will be able to talk about that. But there is some some statements about, her skin being smooth and just, I guess romantic talk is what Ms. Fisk would be able to talk about.
Okay, that you think would echo what Heather Connor would say as she describes her encounters with her father.
Yes, correct.
Okay, all right.
And then I think with Mr. Josh Williams, and I can look up the case law, Your Honor. I don't have it on me right now. However, this is a very progressive county in Fulton County. I know Miss Feely's issue is with the fact that it is a same-sex relationship. However, that can be remedied. Maybe we can give an instruction to the jury. I'm not sure. I don't have that case on me right now, but I can look it up and provide it to the court if possible.
What case law?
Just about how a homosexual relationship is not something that is necessarily prejudicial in this county, but more than that, the probative value of Mr. Connor molesting one of his children is far higher than any prejudicial, I guess any prejudice that would come out of this testimony, as the alleged victim in our case is also his child. So we're looking at the same father-child relationship.
Okay. All right. Thank you. So, Mr. Connor, I want to give you a sense of my preliminary ruling so you and Ms. Feely can have one more conversation about what you want to do before noon. My preliminary sense, but I need to go do a little homework because Ms. Feely has raised some good points, is that I'll allow both of these things in. I am virtually certain I'll let in the Joshua Williams situation. I am not persuaded that a jury is going to be so outraged by the same sex aspect of it that it would make it more prejudicial than the fact that what the jury will hear, assuming Mr. Williams comes in and gives a proffer under oath that that's what he testified to, that his stepfather molested him. That sounds like it is very aligned with the allegations in the indictment. So I'm not making any findings that anything happened, but if Mr. Williams were to testify that you, as his stepfather, made him touch you in those ways, you touched him in those ways, to me, that is powerfully probative in the reason why we let 413 in. I would prohibit the state from making any reference that it was particularly bad because this was your son rather than your daughter. I don't think that hierarchy is appropriate. And I also think that in this jurisdiction, you are less at risk of the jury being inflamed because it was a boy rather than a girl. I think you are at risk of the jury getting pretty upset because it was your child, if the jury believes what Mr. Williams has to say. So I suspect that that will come in. The situation with Ms. Fisk, I'm inclined to let in. I'm going to need to do some thinking about how long ago that was. That was, you measure it in two different ways. It was 30 years ago. It wasn't 30 years from the conduct alleged in this indictment. Conduct in this indictment is kind of old. And so that narrows that gap some. But I want you to have an opportunity to talk with Ms. Feely one last time about the plea. You'll be able to talk with Ms. Feely much more if you go to trial, knowing that it is quite likely, assuming Mr. Williams comes in outside the presence of the jury and says, yes, this is what happened, I'm going to testify to it, and Ms. Fisk does the same, that the jury would hear not only what Heather Connor has to say and the police investigation shows in your case in chief, but that they'd hear about Joshua Williams and likely Ms. Fisk. Okay. Ms. Feely, anything more you want to get on the record? I want to be clear. I'm not making a formal ruling, a preliminary ruling, because of the timing we've got. I want Mr. Connor and you to be able to have one more conversation before he exercises his discretion. And it's 100% his, as counseled by you, as to how he wants to proceed.
The only other thing, and I'm happy and would love to speak with Mr. Connor further, but do we need to talk about scheduling in the event that this goes forward?
So scheduling, one thing I would need is everyone's voir dire before you go home today, so I can work on that tomorrow. But we pick a jury Wednesday morning. So you'll be dressed in street clothes, and Ms. Feely can help make that happen. Either you've got family who can bring clothes in, or we've got a clothing library, stuff that will fit you, unless you want to dress like that. But we'll make sure you're not dressed like that if you choose not to be. But Wednesday morning, we would be in courtroom 1D Delta with 60 people in the jury room, and we'd be picking a jury. So when you meant scheduling, was it more than that? And then trial would start the next day. So that Thursday, we'd be back up here, jury would be there, and we'd have opening statements.
I think with his medical appointments, I didn't know if we needed to take any of that into consideration for.
Tell me what his medical appointments, not what they are, that's private, but sort of when they are, or how you see there being a scheduling issue.
When we spoke on Friday, Mr. Connor was telling me that he does have appointments. Was it this week or next week?
Next week.
Next week. I know July 1st, there is an appointment listed. The problem is we did get his medical records, but they don't have future appointments for safety reasons. So he just kind of gets notified generally when they will be, and my understanding is he had chemo last week, so we're good there, but he would have it again, not this week, but next.
Next week. And so next week, I guess one scheduling issue is we won't be having trial on the 4th. That's a holiday, but we'd be back in action on the 5th. When would you be getting your next treatment? Do you know which day?
Should be next Wednesday.
Next Wednesday. Okay, so that's the 6th. And when that happens, is it in the morning? Is it in the evening? What's that been like?
It's generally been between 12 and like 3.
Okay, so it's in the afternoon.
It kind of varies depending on if they've got a chair available right at that particular moment.
Does it happen at the jail or does it happen at Grady?
Grady.
Okay. I guess what I'd say, Ms. Feely, is we will work with the medical professionals. In no way will I want to interfere with Mr. Connor's treatment. And so if we need to take half days off or something like that, we'll do that. When you get the chemo, are you out of commission for the next few days, or how has that been so far?
It wears you out pretty good.
Okay. So you got it last Wednesday. Thursday, were you able to move around? Just the rest of Wednesday was bad, or how does that?
Wednesday was fine.
Okay.
It's just 3 or 4 days afterwards that it's kind of rough.
Mm-hmm. Okay. Well, if we're not done by the time you need to get it, we may need to have reduced hours that we don't have court for very long. It might make sense for us meaning you or Ms. Feely and you, or even myself and the two of you, to talk with the medical professionals. If they said that there'd be no adverse consequences if the chemo moved to next Friday instead of next Wednesday, then we might be done with the trial and we're not having those things collide. What I do want to avoid is we get 4 days into the trial and then we have to shut down for 2 weeks because you're needing to work through a medical issue. So I'm glad Ms. Feely brought this up. But I'm going to ask that someone speak with the medical professionals to see how flexible the date of the next treatment is, because it sounds like for a few days after it, it's pretty rough for you. Okay. All right. So I'll keep that back in mind. You should talk for a second. Did you have another question for Ms. Feely?
Yeah, there was more than just that one appointment.
Yeah.
I think it was cardio and respiratory.
The July 1st was cardio, and then you had other stuff, but it didn't say Juno there.
I think it was like
July 1st, July 2nd. Nothing this week.
nothing that I know of this week.
We'll just go back and talk. We were just going over the medical appointments that he does have upcoming. He doesn't believe he has anything this week, though.
Okay.
But if I need the excuse to talk with him, I'll clean up the table first.
Yeah. Do you have, you don't have Michael Run. I think the rest are Mr. Cladis, and we need to see where, I know he was with Judge Richardson.
And before we wrap up, Mr. Connor, I'm sorry, Judge, I do have some case law on remoteness. Would you prefer me to email it to you and copy Ms. Feely, or put it on the record here?
If you want to give me just the citations,
Sure.
That's fine. I'll write it down.
Sure. The first one is Sturgis v. State 356 GA App 219.
Can you say that? I'm sorry, I had to draw a little line here.
Sturgis, STURGIS v. State. It's 356 GA App 219. It's a 2020 case. And then there's Harris v. State 358 GA App 2044. And it's a 2021 case.
Okay. I'll look at both those.
Thank you.
You're very welcome. So Ms. Feely, why don't you speak with Mr. Connor a little bit, and then let us know what he wants to do, and we will pivot to Mr. Reynolds and Mr. Tolbert. Ms. McCauley, good morning. Mr. Cladis told me, I think he copied you and others, but he was maybe taking a plea in front of Judge Richardson, but if that fell apart, then it was going to be a trial. I haven't received an update. I'll have Ms. Nelson check in a minute. You haven't seen anything?
I have not.
Okay. Ms. Nelson, can you see if you can check with Judge Richardson's team to see what's going on with Mr. Cladis?
Yes, Judge, I'm checking now.
Thank you. They can't find the paperwork for his sentences? Okay. What does that mean? Let me find his cases first. So we're supposed to start this weekend? So Mr. Sims, tell me what the issue is. You can come on up, because I can't hear you. So you went to the jail on Friday or Saturday and they didn't let you in? Okay. What kind of paperwork did they say they needed? Like your sentence is what's okay. Why don't we do this? I don't know why it didn't work. I sentenced you the same way I've sentenced anyone I've given weekends to, said it just like this. And they should be able to look you up. I'm looking at it right now. Did they give you a note or anything saying you had shown up?
Just told me allowed in the law book, say you allowed my name in the law book, and told me to look at the camera and shit.
So they took a picture of you. Okay. Why don't I have Ms. Nelson, who's a colleague of mine, reach out to the jail to figure out what we're missing. And if we get, I don't think we're missing anything. I don't know what the issue was at the jail, but if there's some document that we need, do we just get it to Mr. Matthews and he'll get it to you? Are you and he in good contact?
I tried to contact him, he said he was
okay. I just want to make sure we have a way of reaching you. Because if we iron it out with the jail today or tomorrow, and they say, great, we'll take him, because of course you need to go back this Friday. I just want to make sure we have a way of letting you know that. So what's the best way to contact you? I guess we'll go through Mr. Matthews. That's the way we really ought to do it. And just make sure we get confirmation from him. So he and his office, they have your number? Okay, all right. Well, so one of them I know is closed because I'm looking at it and it says closed. The other one, let's see. It says closed too, but we'll see. You know, our records and the jail's records aren't always the same.
I tried to see it on Monday, said, and get some paperwork that they got out of this case, they're open.
Well, now you have a few cases. You have an open misdemeanor case still. So I don't know if they look in there and they see, wait a minute, Mr. Sims does have open cases. Like you've got a case in state court, something about headlight violation, and you had another one that was open. So that may be why they're saying, but the two cases that we had, those are not open anymore. Okay, there is a family violence battery that was bound over to state court. It's old, from 2020. It says it's still open also. So if it's the same one, then they need to clean up the system because it's showing as, it's not the case number I had, but we did, all right, you were right, we closed that one. All right, well, at a minimum, we'll figure out with the jail how you can check yourself in, and we'll let Mr. Matthews know so he can let you know, okay? Appreciate you coming in. Mr. Cladis just took the plea and is talking to his client, and we'll head over here. Ms. Feely, any change with Mr. Connor?
I was just going to speak with Ms. Patel, and I don't know how realistic this is, but Mr. Connor, I met with him on Thursday, and then I got the new offer on Friday. We went back out to see him, and he has not been able to talk with his wife about this plea. And I understand that it's, you know, he had over the weekend, he did try to reach her, he was not able to, and he really just would like to have her know what he's doing before he does it, essentially.
Mm-hmm.
And I don't know if there's any way that could happen. I obviously am going to call her as soon as I'm excused, but.
So is there a way you could get her on the phone now? I don't know if she works, but if you could get her on the phone and the deputies would allow you and Mr. Connor to talk with her. I mean, I can get people out of the courtroom. I'll leave too, but you could have a private conversation. Time is of the essence, and I'm happy to ask Deputy Gordon if he's comfortable. You know, if you put it on speakerphone, we turn off the Zoom stuff so that you all could confer.
Sure. And the only other thing I thought was I'll be here tomorrow. I know the court will be too. That's not.
That's not on me. I will be here tomorrow, and I'd be happy to take a plea tomorrow, but that is a conversation that you need to have with Ms. Patel. Why don't we do this? Why don't you and Ms. Patel talk a little bit? And then why don't you see if you could get Mr. Connor's wife on the phone? Mr. Cladis has made it here, and I'd like to handle the Michael Reynolds matter because I think that Ms. McCauley has a bunch of folks here from that, and I want to let them get on their way. Okay, thanks. All right. Good morning, Mr. Gladys.
Morning, Your Honor.
Good to see you.
Good to see you as well, Your Honor.
Is it a good thing that the plea went through?
Yes, Your Honor.
Good. All right. We are going to take up the Michael Reynolds motion that Ms. McCauley filed. Is Mr. Reynolds here? If you come sit with Mr. Gladys, please. All right, Ms. Rivers, are you ready?
Yes, I'm ready.
This is case 18 SC 158-000. And in this case, the state has filed a motion to specially set it for trial. In Ms. McCauley's motion, she provides a depressing timeline of how long this case has languished. A 20-month-old child died in June of 2017, and Mr. Reynolds was arrested for and charged with that death in December of 2017. An indictment was returned in March of 2018, which is quite 4.5 years ago, and here we are. And Ms. McCauley is requesting that this case be specially set because it is high time that Ms. Duffy, the deceased's family, gets closure in this matter. I think the same can be said for Mr. Reynolds. Just as there's been no closure for Ms. Duffy's family, this has been hanging over Mr. Reynolds' head as well. And through no fault of anyone in this room, the case has bounced around from judge to judge, defense attorney to defense attorney. It is time to have that time of reckoning. Ms. McCauley, tell me what else you want to get on the record, both in terms of who's here on behalf of Mackenzie Duffy and anything else you want to get into the record about the need for a date certain for Mr. Reynolds's trial.
Yes, Your Honor. So I'll just kind of work backwards for your request. Here on behalf of Mackenzie Duffy is her mom, Garrett Duffy. Ms. Duffy would like an opportunity to address the court, which I think is appropriate given the circumstances. Perhaps the court can take that up after the state is done with its proffer. But also her auntie, Kiana's here. Ms. Phyllis, her Duffy's mother-in-law, her brother-in-law, importantly, Darius Duffy, the sibling of Mackenzie Duffy, is also here, as well as a number of other family members that have constantly been to court on a number of occasions for this particular case. And I know the court has outlined the various dates, but there are some other aspects of this case that I think are important to bring before the court. And again, none of the state's commentary is reflective of the current individuals that are working on this case. Mr. Gladys has been nothing but responsive, more responsive than any of the other attorneys that have been assigned to this case in the past 5 years that has been open. But this case was originally handled by the Public Defender's Office, who decided after 3 years of representing Mr. Reynolds that they had a conflict with another case and conflicted off. And then it was shifted to Mr. Webb, who did nothing on the case, except for representing the defendant at a trial calendar in 2021. I don't actually think that Mr. Webb even had any conversations with Mr. Reynolds. But then the case was then shifted to Mr. Theory, who was on the trial calendar on April 5th of 2022, who represented to this court that he would be prepared for trial. And then several days before the trial calendar, made a second representation that upon speaking with his client, he realized his client had more information than what he realized and that he wouldn't be ready for trial. And I understand at the time Mr. Theory was assigned to 9 courtrooms, but Mr. Theory was an experienced attorney and made that representation poorly before this court. And then Mr. Gladys has since been assigned. What the state's issue is, and while the state has had a number of representatives assigned to their case, it would not be appropriate for the state at any point in time to come in before the court and say that they were not ready because they brought this case almost 5 years ago against the defendant. But what has happened is it's been assigned to defense attorney, and most notably with the conflict public defender's office, who continues to shift cases to different attorneys, stretching their resources. So I anticipate that and I hope that Mr. Gladys is on this case when the case goes to trial. However, if he is not, the state would still request that whoever is in charge of the public defender's office be prepared, or the conflict public defender's office be prepared to try this case when it is set for trial. It is absurd that this family has waited 5 years to have this case heard. And under the victim's Bill of Rights, the victim's family has a right to proceedings free from unreasonable delay. There is nothing to explain why, other than the shifting that's gone on in the conflict defender's office, to explain why this case has not been called for trial. And in this case not being called for trial, it has represented to this victim's family, and I know that that is not the position of this court, and I know that that's not the position of Mr. Gladys, nor is it the position of the state, but it is sending a message to this victim's family that their daughter is not important, that this case is not important, and that she is just a case number amongst many other case numbers that are shifting through the system. And they are entitled to dignity and respect and to be treated fairly by the criminal justice system. And this is not fairness in any way, shape, or form. So the state would be asking for the case to be set for trial. I have discussed with Mr. Gladys a number of dates that work for both the state and the defense. I've also cleared it with the state's witnesses and their availability, and also cross-referencing that with the jury schedule that has been provided by the court. The date that works best at this stage, that is the earliest date, would be that first Thursday in September. I believe it's September 1st would be your jury selection date.
That is indeed a jury selection date.
So the state would be asking for September 1st.
Okay. So I will circle back to you, and you mentioned that Ms. Duffy's mother wanted to be heard, and I will hear from her. I'm going to say a couple things, and then I need to hear from Mr. Gladys as to the viability of that date. The first thing I'll say is that there's no question that this has been too long. There's no positive gloss to put on this. That is not fair to the family of the deceased. And this may not be your concern, but it's not fair to Mr. Reynolds either. Our system is set up to protect the rights of the accused, and that seems very backwards to folks in your position. What about Mackenzie? What about that loss? Every time we have had to shift defense attorneys and had to, it's not a judge decision. The judge doesn't say, you're off and this person is on. There's not a real good way to explain why. I don't know why the public defender's office stuck with the case for 3 years only to learn that they couldn't. But each of those changes resets a clock. What you do not want to do, even more so than wait, is to have a trial with an unprepared defense attorney, because then we'll try it again. You may get a guilty verdict and feel like at last there's been some progress. There's been some vindication for your suffering, maybe some closure. And then a higher court says, you have to do it again because that lawyer didn't have enough time to be ready. That lawyer was ineffective. And that'll be the number one argument that an appellate attorney would make for Mr. Reynolds if he were convicted, if things were rushed. Now, I don't pretend that anything's been rushed. 5 years, there's no rush to this at all. But each time a new lawyer got assigned, whether it was Judge Downs or Judge Reeder, the people who had these cases before I did, or now with me when I had Mr. Webb, and I don't disagree with the descriptions that we heard from Ms. McCauley, things had to be reset. So I am anxious to hold on to Mr. Gladys. I don't control whether he stays with that office or with my division. But as long as he's here, I'm working to support him in juggling the various cases he has and to help prioritize them. Ms. McCauley is helping me with that project by filing this motion. And I hear it loudly and clearly, and will do what I can to get a trial as soon as is consistent with Mr. Reynolds' lawyer being able to say, I'm ready. If the lawyer says that, then we get past that hurdle of, well, wait a minute, the lawyer's saying, I didn't get enough time. I had the case for 2 weeks and you want me to try a complicated situation. So having said that, and having acknowledged that the system has served no one well in this case, let me ask you, Mr. Cladis, if the September 1 date, assuming I know you have other judges in front of whom you appear, and I'll specially set this, but if I don't pile other cases you have that aren't quite as old, but involve defendants in custody, and frankly, that's how I've been prioritizing it. If there's someone presumed innocent who's been in jail for 3 years, I'm going to try that case before I try Mr. Reynolds. Presumed innocent, he's on bond, so he is not languishing in a jail without a jury having said you did it. And so I don't know why Judge Downs didn't move the case. I don't know why Judge Reeder didn't. I know I haven't put it number one in line because I got a guy behind that door who's been in jail for 4 years and he's presumed innocent. That's not how it's supposed to work. He has had no liberty while the system moves slowly and he has bounced from attorney to attorney. So I'm going to prioritize that over Mr. Reynolds' case. But you reach a point, and this is what happened with Ms. McCauley, where like, you know what? You can't do that anymore to Mackenzie. It can't keep falling behind the cases with defendants who are in custody. So I don't disagree with her. So September 1, if that's the date for which we specially set this, and I otherwise sort of stay out of your hair in late August with my cases at least, is that a reasonable date for you to be prepared to handle Mr. Reynolds' trial?
Yes, Your Honor.
Well, all right, that was easy. Then I will get an order out specially setting, in just for the folks in the gallery. The special setting has 2 beneficial effects. It clears my calendar. That's what I will try that day, but it clears lawyers' calendars as well. Mr. Cladis has 2 or 3 other judges where he has cases, and they're always grabbing his time. We started a little late today because he was taking a plea in front of another judge. But if I specially set this, given how old this case is, the other judges have to get out of the way. They'll say, oh, Mr. Cladis is spoken for. So it protects him in terms of getting ready for this case. So I will do that. All right, Ms. McCauley, what else?
Following that date, Your Honor, for September 1st will be jury selection. Would evidence begin that Friday, or will we start it that Tuesday after Labor Day?
I don't know. We'll certainly talk about that well in advance so that you'll be able to plan for it.
And in planning for that, I assume that we'll have a pre-trial conference. There are some motions. I think the state has a couple motions, nothing overly substantive. Hopefully I'll be able to reach a stipulation with Mr. Cladis, but if we're not able to do that, we have a pre-trial in advance of that date.
Yes, ma'am.
Okay, that's it, Your Honor. The state would just ask if the court would hear from Ms. Duffy.
Ms. Duffy, if you don't mind coming around to stand by Ms. Patel, just so that we can hear you.
Ms. Duffy, could you state and story? State and so that because you're also
microphone on. G-A-R-I-C-A Duffy, D-U-F-F-E-Y.
Ms. Bridges, were you able to hear, Ms. Rivers, were you able to hear Ms. Duffy?
I didn't hear her first name.
It's Garrica, G-A-R-I-C-A.
Okay.
And Ms. Duffy, what do you want the court to know about how this delay has impacted you?
Well, I just want the court to know that it has been a long 5 years waiting, that we don't have no justice, no closure, and no baby Mackenzie. And I just want the judge to hear me out that we can get a trial so that we can get closure for myself and my son and my family.
Okay. Well, September 1 will be that date. All right. Make sure you block it off on your calendar. Thank you for being here, and I'm sorry for the delay. All right, I will get an order out this week, that specially sets this matter. Mr. Cladis, anything on behalf of Mr. Reynolds? We're not talking anything substantively, meaning substantively about the case other than a trial date. I'm sure we'll need to get everyone into court before then to work through some preliminary matters.
Nothing at this time, Your Honor.
Okay, great. Thank you. Mr. Reynolds, subject to the conditions of your bond, you are free to go. And what I'm gonna have you do is go first, and then I'm gonna have the family leave after you are gone. Oh, and you have each other's contact information?
Yes, Your Honor.
Do not wanna, I can't find Mr. Reynolds' situation.
Yeah.
Okay, great.
Okay.
What's up, stranger?
How you doing, Judge?
I'm all right. We'll let Ms. McCauley clear out. I need to get an update on what's happening with Mr. Connor. And then we can spend some time on the Anthony Tolbert situation.
The state does have a request with respect to that case.
Okay, well, let me get the Connor update first because that's on the trial calendar.
I think Miss Feely is outside. I'll go.
Yeah.
Yes. Yeah, okay, I called, it was, I couldn't hear the message. Yeah, like breaking down, so, so I was, okay, or if you're going to stipulate just to go, I think this video recording. Probably, it's probably don't need any much in here. So there's some confusion about that. I'm not opposed to it. I also think something about I haven't heard it here, so that's going to introduce. Just.
So schedule wise, I just want to let you know what's going on. If you think there's a possibility of resolving the case. Today is better than tomorrow because tomorrow is extremely congested. It will be tricky to get Mr. Connor over here. If the state is inclined to be a little flexible, my request would be that if there's going to be a plea, if it's not right now, that we do it at 1:30 or 2 today, because I'd love to handle the Tolbert matter. And then I've got a couple conflicts from 11:30 to about 1:30. But then I'm back, and I think it's better for the Rooks matter, et cetera. If there's a chance that it's going to work out, that we do it today, just more time for everyone to then shift if Connor is not what's going out.
Yeah, I can hold it open until 3 o'clock today, but after that, I really do have to start your travel arrangements ready. So.
You do, and I appreciate that. So 3 o'clock, I start a messy civil hearing. So we'd need to do it before 3. Mr. Connor can always roll the dice Wednesday morning, but it's a plea to the indictment. And that's just a different ball of wax for him. But I also appreciate his desire to speak with his wife. So I don't know if you think we can make that happen, because I think Deputy Gordon has said he'll arrange for it to work if you can make it happen.
So I have not been able to reach her so far this morning. I've texted and called. But I'll keep trying, obviously. The only, I will need to rearrange and have Mr. Farouk coming in to meet with me at 1:30 today. So I may need to make some calls.
Okay.
Speak with Mr. Connor one more time, just to make sure that that's kind of where we're headed.
Yeah, great. Yeah, Farouk could come at 3. You'll be able to see him at 3. But let's leave open till 3 today, the Connor situation, and just keep Ms. Nelson posted. And then if you need Deputy Gordon to create a space so that Mr. Connor can communicate with his wife, I hope she can surface. I don't know what her situation is. Okay, Great. And Ms. Patel, you'll just be on warm standby. If we reach out to you, you can come on over.
Yep.
Great. Thank you.
You have it. I think I Shoot.
All right. Do we want to be on the record to talk about, is Mr. Tolbert here?
He's in.
Okay, so we can bring him out in a minute. Why don't you guys let me know? Mr. Rao, are you filling in for Mr. Abate because he's in trial?
That's correct.
Or are you raring to be back in the Tolbert Williams case?
I think just for the purposes of today, but you never know.
One never knows. Okay. I'm glad you're here. So before we bring Mr. Tolbert out, which we'll do, just tell me what we were going to do was there was this motion that I think Mr. Carlson required the prosecutors to file that has misled lots of litigation managers. Oh, there's this motion and it may not necessarily apply here. It may. I believe Mr. Tolbert gave a statement. I know I've asked a bunch whether they're Bruton issues or if we can try the two defendants together. And Mr. Abate, and you may have said this as well, Mr. Rao, when you were on it, that nope, I think we can try them together, which says to me there shouldn't be issues with statements. But why don't you, I'll start with the state. We are here. What are you hoping we cover today with Mr. Tolbert?
So it was my understanding, and looking at the calendar, was a Jackson Deno until I looked at the procedural history and realized we filed the motion.
Yeah, but we have been doing some prophylactic Jackson v. Denos as brought by the state in cases because the defense has said, I don't know if I'm on to use it. And the state said, well, great. I at least want to know I can get it in. So that's not unheard of. I just didn't know that it fit in this case.
So in reviewing the statement, it does implicate both himself as well as the co-defendant in the case. If I did say that there was a possibility we could try the case without any Bruton issues, I apologize. So I do think it is necessary for the court to find whether or not the defendant did provide that statement through the involuntary plea, which I think is the purpose of what we were trying to do today. The issue of that was that Detective Benton is the lead detective on this case, and there were some issues as it relates to her availability, specifically as it relates to Thursday. She's on some special project assigned by the district attorney as well as the mayor.
The last time we got her, she was in a room with boxes. She testified from a room she did not look happy.
So that's the similar situation that I find myself in today. That is one option if the defense is willing to. The other option is to stipulate the authenticity of the video recording. I think the court should be able to make a finding of fact just based on that first 15 minutes. Or if the court is willing to grant a continuance from this matter.
Okay, so there is a statement, only one statement. You would intend to use it in Mr. Tolbert's trial. whether Tolbert is tried with Williams or not, you would intend to use it in Tolbert's trial.
Based on my review of the statement, I do see that as being a beneficial piece of evidence in the state's case. So at this point, not being the assigned prosecutor in this case, I would see that as evidence that would come in the state's case in chief.
Okay. Mr. Cladis, again, we'll get Mr. Tolbert out here in a minute and get on the record. How do you want to proceed? Scenario one, that I'm ranking them now. I've done this a lot with the Jackson v. Denos. Is look, no one contests that the video is the video, and you're going to watch it, and either Benton did it the right way or she did it the wrong way, and go ahead and watch it. You could make some argument now if you've watched it to say, hey, what I want you to look for is when my client says, I don't want to talk to you, and then she presses forward. So that is one approach. Another is that we could get Detective Benton remotely, and she could say, I've looked at it, and that is in fact the video recording of my interactions with Mr. Tolbert. And then a third is we drag Detective Benton all the way in here to say the same thing.
I'm not inclined to go the third route. Normally, we like to do these things in person. My bosses particularly like us to do these things with everybody in person, but I did not file this motion. I've watched the statement. I don't see this as a statement that's, you know, I've had lots of other hearings where it requires a lot of argument, a lot of contesting whether it's coming in. I don't know that this is going to be one of those.
Okay.
So the first option would involve us not watching the video at all today.
So the first option would be that you would stipulate to the authenticity of the recording of the interview. I would commit to watching it. I wouldn't watch the whole interview. I would watch up until I concluded the interaction that yielded or failed to yield the Miranda waiver had occurred. That's what I typically do. And then I reference that in my order. I watched this. There was a recording. Detective Benton was in the room with Mr. Tolbert. Here's what happened. He was handcuffed. He wasn't handcuffed. And that's how we'd handle it. I don't get a lot out of it being played in front of me because I'm going to go watch it again anyway, unless there's something where there's this contention that that's when she hit him. She didn't hit him, that kind of thing. But that since it's on video, there's usually not a dispute. There's maybe legal argumentation about was it an equivocal or unequivocal invocation? The maybe I should talk to a lawyer. But again, he said what he said. And if it's maybe, you can argue that. I know the case law, probably not going to prevail.
What I would say if the court would like to do it this way, I'm okay with the first option. There are a couple things I've watched the video. There are a couple things I would want to check. I might submit an argument to the court. I don't know if the court prefers something via email or if I file something with the court.
So if there are cases that you think are particularly on point, and that's really all you wanted to get in front of me, an email to me and Ms. Nelson and Mr. Rao saying, hey, Judge, I think you should read these cases. That suffices. I don't want to preclude you from doing anything. If you want to say, here's a letter brief, this case because, or hey, you're going to read this case, doesn't seem entirely on point, but think about it this way, Judge. And if you think about it this way, you'll see why it supports my argument for suppression. And I will certainly give you time to do, we'll get all that on the record. So you can say, I want a week to do this, or I want 3 days, and I'll stay behind that timeline. So I won't watch it tonight if you say I want X days to get something in. Does that work?
It works for me. Thank you.
Okay. Can we bring Mr. Tolbert out?
While that's happening, Your Honor, Mr. Connor has informed me he does not wish to go forward with the plea today.
Okay.
And he understands what that means.
Okay. So we'll see you Wednesday morning. Maybe before, I just want to make sure we work through the medical situation. So I don't know how you can pry that out of the jail or who does that, just so we can schedule. But it sounded like we're good. I forgot to ask Ms. Bata, how long do you think this trial will take?
With the two similars, I think that probably 3 or 4 days.
Okay. And that would include your presentation as well. Okay. Ms. McCauley, you had the case for a while. You agree that it's not a 9-day trial?
No, it's 4 days max.
Okay.
Maybe 5, including jury selection, because sometimes I can go a little long with these cases, but.
Yes, it can. That was a reason to work the case out.
Yeah.
Jury selection.
But no, I think that assessment's correct.
Okay. If you could please, if you haven't already, get your voir dire to Ms. Nelson. That's the thing I start working on. Jury charges we need, but no one's going to work on them before Wednesday anyway. And then just because we're now on a short fuse, if something comes up, just right away email Ms. Nelson and me and Ms. Patel so we can work through what we need to work through. Okay. Thank you for having those conversations. All right.
The evidence starts Thursday, Mr. Connor?
Yes.
Okay.
Yep. So we'll do 2 days of evidence before the 3-day weekend. So pick the jury Wednesday, Thursday, Friday evidence. Monday is a holiday, and then we're back at. We have to start a little bit late on the 5th, but that'll be a half day of evidence, and we'll keep going. Okay.
Thank you.
You'll let Ms. Patel know.
I will.
Thank you.
Thank you, Judge. Thank you for entertaining my motion.
No problem. All right, Mr. Tolbert. Good morning.
Good morning.
We're going to get on the record in your case. That is 19 SC 167684, State versus D'Anthony Tolbert. He's got a co-defendant, Ramel Williams, but we're here today to talk about Mr. Tolbert's case. With him in court is his lawyer, Mr. Cladis, and representing the state is Mr. Rao. Mr. Tolbert, we're here because the state filed a motion asking me to rule on the admissibility of the statement you gave the police. I had a brief conversation with the prosecutor and your lawyer before we brought you out here, just so I could understand what the concerns were. And I think the way we're going to handle this, the state has a recording of the interview, as does your lawyer. And I don't know if you've seen it before. I know you've been through a few lawyers, but Mr. Cladis is going to figure out how to get with you out at the jail so you can watch it. But it's a statement you gave, so you'll remember. You met with the Detective Benton, said whatever you said. And Mr. Cladis has some arguments about why maybe what you said to Detective Benton was not the product of a valid Miranda waiver, or there was some problem with that process. The state wants me to rule that it can come in. And so the way we're going to handle it is that in a moment, Mr. Rao is going to tender whatever exhibit it is. I assume it's going to be States 1. And I'll have the video so I can watch it. And then I'm going to talk with Mr. Cladis, your lawyer, a little bit about his concerns. And then he asked for some time to get me some cases that he thinks I ought to read that support his argument. Okay? So Mr. Rao, when you're ready.
Yes, Judge. And so just for the purpose of the record, I don't have a exhibit sticker.
I'll put one on.
I'm going to tender what I would like to have pre-marked identification.
Can you just, if you'll be by the podium, that way Ms. Rivers can hear you and you can hold on. I'll get it from you when the hearing's over.
Yes, Judge. What I would like to have identified for the record as States Exhibit 1, which is a flash drive, it's a 32 gigabyte flash drive containing the statement of defendant D'Anthony Tolbert in this case, which is the subject of this hearing to determine whether or not the defendant freely and voluntarily made a waiver of his rights and provide a statement to Detective Benton.
Okay. Mr. Cladis, my understanding is that you don't contest the authenticity of the interview. It's a recording of whatever was said. Your focus is, as it should be, on the contents. Is what Detective Benton said sufficient to protect your client's rights, or did she fail to meet some of those requirements? Is that a fair statement?
I think Detective Benton, I've watched the video. I think Detective Benton does read the Miranda warnings, does discuss that with Mr. Tolbert. I might have some question about the voluntary of the statements separate from Miranda. And so I need to do a little bit of research and a little bit of looking into the file we have in my office on Mr. Tolbert's case before I can decide that.
Okay. Voluntariness in terms of whether it was a knowing waiver on your client's part?
Knowing and whether his mental condition was such that it made it not quite voluntary.
Okay. Because of something that was going on at the time, or something that is more permanent in Mr. Tolbert's situation?
More permanent, Your Honor.
Okay. All right. Well, I will admit States 1 for the purposes of this hearing only. I will review the pertinent part for my analysis, which would be that initial interaction between Detective Benton and Mr. Tolbert. But I won't do any of that review until Mr. Cladis has had a chance to look through the file a bit more, presumably speak with Mr. Tolbert, and then file whatever you want to file. And I say file, you could file a brief if you want to. It's also perfectly acceptable if there are just a couple cases you want me to be aware of. An email to me and Ms. Nelson and Mr. Rao suffices to get those cases in front of me.
Yes, Your Honor.
How much time would you like before I turn to the video to watch it?
I think I can. Well, one more thing I needed to ask the court is if the court would issue an order allowing me to bring my laptop to the jail so that I can watch the video with Mr. Tolbert.
I will certainly do that. The way I handle that, and you maybe can get a go by from Ms. Wood or one of your colleagues from the public defender's office. They shoot that to Ms. Nelson. She gets it to me and I sign it. It has your name, obviously Mr. Tolbert, and your need to get with him in a setting at the jail where you can play these videos.
Okay. And so I already know from trying to set up a similar visit in another case, I'm not getting any responses from the jail. I've been waiting for a week now to hear back on setting up the same kind of visit with another inmate. So maybe I could get this done today or tomorrow. I think they only do visits on Tuesdays. Actually, no, so Monday won't work. So Tuesdays, Wednesdays, and Thursdays are when they do their contact visits.
But you're supposed to, you can't just show up. You have to like book it and they give you the green light to come over.
They have to arrange staffing for the contact visit because you have to do it in the law library. Someone has to sit there with you the entire time. And so I've learned the not so hard way that you can't just show up.
Okay.
I want you to schedule it.
You could see Mr. Tolbert on any day, but it wouldn't be a contact visit. You'd be in a lawyer booth.
Yes.
And you wouldn't be able to say, watch this video.
The sound is kind of hard to hear through the glass.
Sure.
So that would be the issue with
Okay. So you and Mr. Tolbert could have a conversation, but you wouldn't be able to meaningfully review the video.
No.
That would be the contact visit for which you submit a request and they, in whatever way, get back to you.
Yes, Your Honor.
Okay. So get me the proposed order. If you continue to hear nothing back, also let me know that because I'll need to reach out to the jail to say, what are we doing to accommodate these contact visits? We can't move our cases if we can't have the contact visits.
Thank you, Your Honor.
The worst case scenario nuclear option is we bring someone here, but that's really inefficient to do. Okay. So why don't we do this? I won't start watching the video until you let me know you've had a chance to do what you wanted to do.
Okay. Thank you, Your Honor.
You're welcome. All right, Mr. Rao, anything else in Mr. Tolbert's case?
Just for the court's edification, Judge, it is approximately an hour and a half long video. However, looking at the actual portions that are relevant for the purposes of this hearing, there's interaction between Detective Benton and the defendant between minute marker 6:30 till minute marker 38:40, at which point in time that interview concludes and Detective Benton leaves the room, but then returns at hour marker 1:07, 20 and 20 seconds. And that portion ends at hour marker 1:18 and 20 seconds. For the purposes of what I believe is relevant for the Jackson Deno hearing, the engagement starts at minute marker 8:20, where Miranda rights are read to him, and at minute marker 11:10, the defendant signifies verbal agreement to speak about the case.
And then they talk for 30 minutes. Detective Benton says, I'm going to be back. And she's back at that 1 hour and 7 minute mark.
Correct. To verify some information that the defendant provided. And what I will note to the court is the defendant does indicate to her that the reason why he did not call police is because he was scared of the defendant, and does reiterate that, he was scared of the defendant, which of course would not be any sort of threat or fear that's sponsored by any state action.
Right.
Jackson Deno.
Okay. Got it. Excellent. Then that's what we'll do. So Mr. Tolbert, Mr. Cladis is going to figure out how to get out to the jail with his computer. So you and he can review that and maybe other aspects of the discovery. once that's happened, then Mr. Cladis will let me know that I can rule on this. We'll keep moving your case towards trial and see when we can get you and ideally Mr. Williams in here for that trial. Mr. Cladis, anything else?
No, Your Honor, thank you.
Mr. Tolbert, you have a question?
I was just gonna ask, can I get a full copy of everything y'all have in my discovery because I don't have it?
Sure. So when you say y'all, I don't have your discovery.
I'm just saying everything that the DA and the prosecutor have on my case. Because I've been going months and probably some years without having
knowing what's in there,
know what's going on.
So when Mr. Cladis comes to visit you, he can bring the paper, which you can keep. He can't give you discs and things like that. But Mr. Cladis, when you do manage to connect with Mr. Tolbert in that contact visit, if you could make sure you've got with you, I mean, if it's 1,000,000 pages, that's not practical, but there are highlights I'm sure you could provide him.
I believe Mr. Tolbert has the paper discovery, but there's a lot of some digital evidence that has not been shared with him by prior counsel that he hasn't seen and probably hasn't had described to him in much detail. So
okay, I
will be doing that. So.
Good.
Hey, excuse me, Judge McBurney. I wanted to go over I didn't get indicted in my 90 days. I got indicted in 4 months from February 1st to May the 10th. You heard me? And by state law, I'm guaranteed a bond.
So that's a conversation for you to have with Mr. Cladis. I don't know that you may be right. I'm not disagreeing with you, but I don't know that now is the time to fix that. It would have been back then, but I'm not sure. And I'll let you and Mr. Cladis talk about that. And if he thinks that there is a good legal reason for us to be talking about bond, we'll make that happen. That does not need to wait till trial. Okay. All right. Thank you, everyone.
Thank you, Mr. Mayor. I'll be there to see you. Okay.
All right.
Thank you. Exhibit 1. Exhibit 1. How are you feeling? Good? All right. Come on back. So 3 o'clock, unfortunately, no plea. Take care. 3 o'clock, I'll be out here. I don't know if they're showing up in person, but civil. But that should be it for back there. All right? Thanks.
Sure. We can make sure. Oh, so fine. Yeah. Oh.
You brought your lunch? You don't go out to eat. Oh, no, I will. Very rare though. I don't see you on that. I think you got enough money. If you don't go out to eat, you bring your lunch every day.
So I did the math, I was all week. But then sometimes I'll be buying food for everybody else.
You never asked for me, so I would
No, I'm just saying. I just, now you need some, I got it.
You got all the different chicken now. You can peel packs and crackers and I have mayonnaise, I have relish and all this.
I have food. I don't have food. I have food, I don't have food.
I had two, three. I give them to y'all one, and I give somebody else.
Where's the still, you leave us there?
Huh?
You leave us there?
Who, William still? I'm gonna go help him. If he get in trouble, you might leave.
Oh, so what we doing, bro? What we gonna do?
Probably until we down until.
What came the tree?
So Jackson, you know. Round. Well, I agree with you. Yeah, that's cool. I'm still ready to go. Yeah, let's see. Is it all? Is it like it's all? Is it like?